Hello, Bay Area. Let's do this Ask Me Anything, where we answer your questions about estate planning, asset protection, and just anything you have to ask regarding the law. If we can help, we're going to answer it. Here we go. Question number 1. I lost my stepdad a month ago, and one of 3 stepdaughters took everything. There's no will. He married my mom about 25 years ago, and then they divorced. He never had another wife or kids, never adopted us girls, but he was a good father to us. My sister took everything. He always insisted there was a will and it disappeared. How can I get my share and how is it legal? She can take it all. It's so unfair because me and my father were the closest, and just because she's living with him, she assumes it's all hers. How to start probate? Okay, I'm very sorry to hear that you lost your stepdad, and I'm glad that you guys had a close relationship together. The unfortunate thing is if he never adopted you, you are not legally his heir. So first lesson here, whoever ever tells you that I have a will and when they pass away, you can't find it, guess what? If you have a will and you pass away and no one can find your will, it's as if you've never had a will. No will exists. There's no such thing. Why? Because if I can't find the will, then it doesn't exist. So if you're saying he has a will, but you can't find it, then there's no will. So my recommendation to you is go find that will. Here's the hard part. Sometimes when the family member, so you're saying your sister was living with him when he passed away, so your sister was in the house, maybe your sister knows where the will is. The point being is I can't say if she's doing some funny business. I really don't know who your sister is. I don't know anything about your family. But yeah, there's been moments in history where people have taken the wills and hid them. And that is totally illegal, but who's there to prove that it actually happened? This is one of the uglier areas of estate planning and loved ones passing away and what happens next. Some of this stuff is just totally out of the law's control, out of the court's control, and there's nothing we can do about it unless you know. This is why I always tell my clients, when I create a will for my client, I give them original and I give them a copy. And I tell them, go put the original in a safe place. Write down where you put the original and store the copy among your estate planning documents. That way, for instance, if you've had a copy of his will, and it should say copy on it, it shouldn't say act as the original will, that's also illegal. But by having a copy, you can show the court that an original does exist and it's somewhere. And if you can't find it, sometimes the court allows you to admit the copy of the will, all right? But right now, it sounds like you don't have a will. So let's move forward as if there is no will, because if you can't find it, it doesn't exist. Do you need to start a probate? First, is your sister entitled to take his share of the estate? No, not at all. In fact, what she's doing is illegal. Do you feel as if you want to teach a lesson, take revenge, that kind of stuff? I know those feelings, those emotions, they do come here like, this is not fair. I hear it. I hear you. I think the best thing you can do right now is, yeah, go start a probate. How do you do that? You go find an attorney, wave your hand at them saying, I need your help, and we will help you file a petition for probate with the court, and you can ask to be the executor or the administrator of your dad's estate. But even if you're administering your dad's estate, you have to find out who your stepdad's true heirs were. If it's not you, because you're not adopted, so you're not a blood relative, then it's probably going to be one of his blood relatives. Well, if he doesn't have children, then the next question is, does he have a spouse? If he doesn't have a spouse because your parents and him divorced, then you need to go looking for your dad's heirs, his parents, if they're still alive. If they're not alive, his brothers and sisters, his nieces and nephews. They are legally the ones entitled to your stepfather's belongings and everything that's left over. You and your sisters, because you are not his children and you have not been adopted by him, you might not legally be able to inherit. However, there's a very big caveat with this. It all depends, as any attorney will ever tell you, it all depends on what is actually happening during your relationship that you were children with him. So you're saying that your mom and him were married for 25 years. So you've been living with him for 25 years. Did he put out that you were his child? Even though he didn't adopt you, you might be able to start a legal proceeding to legally call him your parent. You might have to do this in tandem with the probate or right before the probate or through the probate. This is the harder part that we have to look into. What's the strategy? What's next? But California law does have some carve-outs for children that are not actually blood relatives of their caregivers. The caregivers have been raising them throughout their lives, have been putting out to the world that, oh yeah, this is my son, this is my daughter. stuff like that. There is a way where you can say, okay, because they've been calling me their child, I've been living with them, I've been raised by them, we've been living together till the very end, or obviously past adulthood, you can say that that was my parent. It gets a lot harder when you become an adult over the age of 18. It's much easier if you were a minor, but I believe California law says that if you were living together as a minor when your parents got married, so when your mom married your stepdad, were you a minor child and were you living out home with him? And then after that point, obviously you grew up, you move out of the home, he continued to say to everyone that you are still his child. Stuff like that, it's a little gray. There's no black and white answer here. This is a judge is going to decide if yes or no. I think a judge may decide if you don't find any of your dad's own relatives and heirs, that they would say, okay, we don't see relatives or heirs. Okay. And he's had a lifelong relationship with you guys. 25 years is a very long time. Then yeah, you guys are his kids and you can inherit, but you got to go through those legal hurdles first. But if you don't want your stepsister swindling the estate for everything it has from your stepdad, the first step is to start that probate and let the court help you understand who should be inheriting his estate, whether that's you or not. Now, here's the rub. If you go and set up a probate and you become the executor, executors actually get paid a certain percentage of the fees under the law of the estate. So there is a way that you could inherit assets from her if the court appoints you as the executor. The hard part with that is, once again, you don't have legal priority if your stepdad has other blood relatives that come out of the woodwork and say to the court, oh, wait a minute, I don't want her being the administrator of my brother or my cousin's estate. I want to be the administrator. And then there is an area of California law that it is literally black and white laid out on who has priority to become the administrator. There's a little more strategy and a little more research that has to be done. I can't just fully answer it here because I don't have all the detail. You're welcome to reach out to me if you like some support. Otherwise, I recommend you reach out to a probate attorney and get that process started. The longer you wait to do this, the more time you're giving your sister to pull money out of the estate and put it into her pocket. She'll be liable for that in the future, but the thing is if she goes and spends all the money and then you sue her and say, okay, you need to give it all back, and she doesn't have money to pay it back, how are you going to get that money back? Think about that. Practically speaking, don't wait. Get started, file that probate. All right, next question. If I have a will in another country, will that be applicable in California, or do I need a separate will in California? Okay, this is very easy. Generally speaking, if you create a will in another country, and I have we're in California, we are a cultural melting pot. There's so many people from different countries, different cultures, and they're not even fully rooted here. They still have roots at home. Sometimes people come here, maybe from the UK, from Canada, from the Philippines, what have you, and they have wills that are written in those countries. And if they don't do any other estate planning and their family members say, okay, mom is in the Philippines, she has a Filipino will, and she has real estate here in California, and we need to go through probate to pass that on to me and my sister, and I lodge that Filipino will in the US court here in California? Absolutely. And most of the time, the court will accept it. And the court may ask, what is the legal procedures or requirements for creating a will in the Philippines? They might want to make sure that it's a valid will in the Philippines, but that's about it. If there's anything unorthodox, kind of, so to speak, with the will, something strange about how it was created, terms that are put in it, then most likely the court will not accept it. So remember this. Just because you have a will does not mean that it's going to go through probate and everything's going to be peachy. Only a judge can authenticate your will. This is why we have your will witnessed by people. So those people can show up in court if they're still living, and they can attest by their witness signature that yes, that is the decedent's signature right there on the will. I was there when they signed, and there you go. Now, maybe the Philippines says you don't have to have two witnesses, but you need one. In California, you have to have two witnesses sign your will. Does that invalidate the will here? No, because if it was legally valid in the Philippines, a court might accept it. Same thing if your will's in another state. Let's bring this back home to the US. What if I moved from New York? I have a will that was created by an attorney in New York, and let's say New York says you don't have to have two witnesses signing your will. That's not true, you do. But for the sake of example, let's say they don't. Will a California court be able to reject that will? No. If it's valid in New York, then the Constitution says California has to recognize the laws of New York. So a judge will accept that will. It's not hard. The only time I've seen foreign wills never accepted is when they looked a little too kooky, not like a normal will. Remember, wills are pretty standard stuff. We've had this concept of wills for over 1,000 years. It's really well-established law. This is not something new to the judge, not something new to the law. I think you're going to be just fine. Just make sure that you followed the right legal procedures in creating that will in that country. Long story short, if you're uncomfortable, create a will in the US. You can have wills created in multiple different countries. You don't have to just have one will. I can have a will for my US assets. I can have a will for my Mexico assets, and you go through the courts there. I think that's a better idea. I do think it might be a better idea idea to create a US-based California will on top of your foreign will because it just makes things simpler for the family on the road. And as long as the terms of both wills are not too crazy or completely different from each other, then you're going to be fine. There won't be a conflict, for instance. Plus language. If your will is in another language, oh boy, you better create a will in English or get a good translation because the court will not want to be responsible for translating your will. That will get very ugly. Most likely a judge won't accept the will.